Thanks. Good afternoon, everyone, and welcome to session 5 of the South Carolina Small Business Development Center's Intellectual Property Series. Thanks for joining us today. My name is Jennifer Groff. I'm a librarian and Patent and Trademark Resource Center representative at Clemson Libraries, and I'll be the moderator today. So for those not familiar with the South Carolina SBDC, it's a statewide organization that serves the needs of both urban and rural businesses. The SBDC consultants work with small businesses at all stages of development by offering free consulting assistance to help existing businesses grow, as well as assisting entrepreneurs and innovators who wish to establish a startup. The SBDC does one-on-one consulting with companies and offers educational and training seminars, such as these IP webinars, to inform businesses so they can be positioned for commercial success. So today's session, which will take the form of a panel discussion, will cover intellectual property management. On the panel today, we have Doug Lineberry, a patent attorney from the law firm Burr & Forman, LLP, Jeremy Stipkala, a patent attorney from the law firm Thrive IP, as well as Earl Gregorich and Tony Del Campo, both from the SBDC. The panel will explore strategic considerations that an innovator or entrepreneur should contemplate regarding filing and maintaining intellectual property in connection with their business. And each panelist will present a few slides on each of these topics. So these are our smiling faces once again. I'll be monitoring the chat box as you've heard. So if you have questions during the webinar, please type those into the chat and we'll respond either during the presentation or at the end. So now I'll hand it over to Tony Del Campo, who will start by discussing business considerations regarding IP.
Well, thank you, Jennifer. Certainly appreciate it. And good afternoon, everyone. And thank you for joining us once again for our session 5 of our webinar series. Again, my name is Tony Del Campo, and I'm the Technology Commercialization Business Consultant for the SBDC. Over the past 4 sessions, if you attended our webinar series, you heard from our panel about various aspects of intellectual property. And today the webinar will discuss some of the strategic considerations when an innovator has an idea or an author may have generated some creative work. So you have an idea, you have a creative work, what are you going to do? One of the basic questions that comes to mind is whether you should legally protect it in the form of a patent, trademark, or copyright. Well, the decision, as they say in most things, really depends on the several factors, including what type of idea or creative work that you may have. You may ask yourself, do you intend to commercialize the invention or creative work, and in what industry? Do you intend to start a business or use it in an existing business? And in this regard, a central question has to be asked, and that is, if I protect the particular idea or work, does it add value to the commercialization potential? And in other words, can the protected IP make me money? I mean, that's really the bottom line, in my view, if you're in a business. So this is an obvious question, but because protecting IP will ultimately involve an investment, an initial investment, in some cases, the cost could be quite high. So one needs to be very confident that making that investment is consistent with a reasonable expectation that the expenditure will result in some future return on the investment. So can you do the next slide? Jennifer, sorry. Thank you. So if you recall from our previous webinars, the value is really based on the concept, that is the value of IP protection is really based on the concept that allows the IP owner the right to exclude others from practicing the invention, that is making, using, selling. In effect, you're creating a monopoly for the owner for a limited time. And if you look at the picture of the tree here with the fence around it, to me, that's a really good representation of what intellectual property can do for you. Think of the tree as being your intellectual property, and the fence is protecting your intellectual property from others practicing it. So this ability to exclude others forms the basis of establishing a competitive advantage. And that value of the exclusivity that the IP gives you really depends on the industry and the subject matter that is being protected. For example, if you have a new drug formulation that has been shown to successfully treat a medical condition, well, obviously that could represent a substantial market value. And in the case of a trademark or copyright protection, not only do you gain exclusivity, but the IP can also confer a sense of quality or reputation, which certainly can add value to the IP owner. And finally, in the case of a company, the competitive advantage of owning of IP may even lead to improved opportunity to raise capital for the company. So obviously the value of the IP cannot be overlooked. Next slide, thank you. So it should be appreciated then that the IP protection does not necessarily convey that the IP is superior, or I'm sorry, that the IP conveys that the item that you're protecting is somehow superior, or in fact the product or the service does what you say it does. In the case of a patented product, it simply means that the idea has met the requirements of utility and novelty under the US patent law. So therefore, it's really up to the owner to demonstrate that the patented product does what is advertised and you do this by acquiring data, in many cases through the use of a prototype or other comparative experimentation to show that indeed this idea that is now patented, it really does what it's supposed to do. Likewise, a trademark or copyright on its surface says nothing about the quality of the creative work or trademarked product, or that it is better than any comparable products. Over time, however, the owner of the IP, through skilled and strategic business development efforts, these trademarks or copyrights can become recognized by consumers as a symbol of positive reputation and superior quality associated with the products that they represent. So the bottom line is, while IP can provide an element of competitive advantage, the mere fact that the IP protection does not necessarily say anything about the product or service. So, but the owners of the IP can use the advantage of the market monopoly afforded by IP protection to demonstrate the superiority of the products covered by the IP. Next slide, please. Another question that should be considered when you're thinking about filing a patent or copyright or trademark is, how broadly do you want it to be filed? Do you want it, only in the US or globally, that is in other countries? Typically, a US-based company or individual will file in the US as a default, since that's most likely the market which the owner wishes to sell into. And indeed, that's usually a good decision because it's generally understood that the US market represents about 50% of the global market share for most industries. But that being said, filing in other countries really depends on the industry and the subject product or service. Utility patents, such as those in durable goods or the pharmaceutical industries, which have global markets, the tendency is to file in several countries in order to achieve protection in those markets. Likewise, creative works or trademarks, an IP owner may wish to ensure protection much more broadly. But given the cost to obtain foreign protection, particularly in the case of patents where costs can be quite high and they can escalate rapidly, the decision has to be one that's driven by the business to determine if those additional costs can be recovered through revenue generation outside the US. So for most small businesses, I would argue that whose primary markets are closer to home, US protection is generally sufficient. So continuing with this idea of managing IP costs, even if you limit your filing into the US, it can be costly and lengthy process, particularly in the case of patents. And I know our two patent attorneys on the panel today will talk more about costs later on. But owners have to carefully manage the patents related to the expense in an attempt to minimize such costs. The IP owner one of my recommendations would be to work very closely with the patent attorney to provide any information that is requested related to the file so that the patent attorney can make timely responses to the USPTO, and in doing so can avoid the payment of fees to extend deadlines. Similarly, if one can avoid payment of surcharges assessed with maintenance fees that are due after the patent has issued. by paying these fees on when they are due. So the bottom line here is that IP protection, particularly with respect to patents, is an expensive process. And so there has to be a careful control of those costs whenever possible. Now, as I mentioned earlier, IP protection confers the right of the IP owner to exclude others. And the value is based on the concept that allows the IP owner the right to exclude others, as I mentioned, from practicing the invention. In effect, you're creating a monopoly for the owner for a limited time. But this protection is only good, and I always tell my clients that this is only good to the extent that the IP owner is willing to defend such right. IP owners then need to be aware of their competition or new players that come into your industry as potential infringers. And if you believe that potential infringement might exist, it's always advisable to consult with your patent attorney for advice to see whether or not indeed there is infringement. And if so, they can help you. That is, the patent attorney can help you advise you on what steps can be taken to put those infringers on notice. So that's very important if you want to defend your IP. So some final words here with respect to IP protection. And obviously it's an important part of any business plan, but like any asset, there are costs involved and it should be viewed as an investment that can advance your business goals. But in my opinion, I think it's always wise, if you have an idea, to do a bit of research on your own, which is quite easy using the internet or other publicly available sites like the USPTO to do a search on your idea. And then, of course, if you believe that you have something that should be patented, seek the advice of a patent attorney who can then help you can use some of that preliminary research search material and help you then decide whether you're going to actually file a patent or trademark or copyright. So in my view, the IP protection should be a strategic activity, which can lead to a successful business if leveraged appropriately. But of course, IP in itself doesn't guarantee business success. Like most business assets, it's an investment that has to be, that can potentially pay off if it is used wisely by the business owner. And with that, I'll turn it over to the next presenter, which I believe is Jeremy, correct?
Yes, thank you, Tony, for those strategic insights. I'm going to build on Tony's words of wisdom to discuss in particular your strategic considerations when it comes to thinking about your patent portfolio. As Tony mentioned, you really want to think about searching before you file your patent application, because that gives you some very good insight. Let us suppose that you have invented, for example, the remote control television. Well, you want to see if you can sell remote control televisions, for example, whether anybody has unexpired patents on, let's say, the television still enforceable. But also it gives you an idea of what you can patent. Let us suppose that those prior patents on televisions that may preclude you from patenting the television aspect of your remote control television technology. But, so now you know, in this hypothetical situation, you might be able to patent the remote control aspect. And if somehow patents are not desirable or available to you, you might also consider trade secret protection as an alternative. And indeed, I urge you to consider trade secret protection for many aspects of your intellectual property. Just brief review, a trade secret is commercially valuable information that is subject to reasonable efforts to keep it secret. So you do have to take steps to keep it secret, but that's where a lot of intellectual property is born in trade secret land. Strategically, you have to ask whether you or your colleagues have disclosed the technology and in what context. A public disclosure starts a one-year clock in the United States, during which 1 year you have to file for a patent in the United States. However, overseas, any public disclosure, and that could include an offer for sale, an actual sale, of course, a publication that discloses your technology, an advertisement saying, hey, here's my invention, please inquire about buying it. That kind of disclosure can destroy the ability to get a patent overseas. So when you're thinking about your intellectual property at a very early and strategic point, you want to think about how you're going to disclose this technology before you commit to any such disclosure, because that might, like I said, impact your ability to get a patent. At some point, you're going to make a keep, sell, kill analysis of a patent, or indeed looking at your entire patent portfolio. What do we keep? What do we sell? What do we kill? And the answer for any given intellectual property will turn on whether that intellectual property holds value for you and for your company. And that value could be, of course, protecting a revenue stream. You're the only one selling remote control televisions. That's money in your pocket. But it also might hold value in other ways. You can advertise that, yes, your product is patented, and people will be attracted to your product because it is patented. It also may hold value in that your competitor who makes televisions might be a little bit wary of suing you on their patents, because you hold patents that you might sue them right back using those patents that you hold. So that's value too. It's not cash in your pocket, but maybe it's a lawsuit avoided, and that's of course valuable. Bottom line, as Tony said, can you monetize? In some way, does that patent serve your bottom line? Revenue, avoiding disputes, whatever that might mean to you, to your business. And if so, then keep it. If not, maybe somebody else can monetize. That's when you sell it. And if there's no value there and there's no monetization possible, that's when you might make the decision to kill something, especially at a time when it's time to invest more in keeping that patent alive. Let's say when you have to pay a maintenance fee so many years after issuance. Well, do we really want to spend that money on this patent if it's not holding value for us? Next slide, please. Where do you want to file for patent protection? We're talking about the countries in which you might want to file, and Tony touched on this. I'm going to ask 3 questions here. Where is your market? And as Tony pointed out, for many intellectual property owners, the answer is the United States. But also, let's look and see where your infringers are. Yes, wouldn't it be great to get a patent around the world, or patents around the world in every country where you might possibly have a market? But if you become aware or believe that your chief infringers, let's say, are in 1 country or 2 countries, let's just pick on China. No offense to China, but let's imagine in this hypothetical that most of your worldwide infringers are going to be in China. You might consider, well, let's get a patent in the United States to protect our primary market. Let's get a patent in China, and that might foreclose infringement not just for China, but for many countries, many other countries as well, if that's where your chief infringers are going to reside. Also, you have to look at your resources. It does no good to commit to a worldwide campaign of protecting intellectual property that halfway through you just run out of steam and you just can't execute on that. Some of those resources would be better diverted to, let's say, building up your U.S. market or what have you, or innovating the product further. So we do need to ask about resources to enter into all these different countries. Another thing to think about is that the patent application process takes between 1 and 5 years. I've gotten a patent in a year. That's rare. I've gotten patents that took 5 years. That's rare as well. It's usually in the middle there, somewhere around 3 years. But again, it's hard to predict. There are ways to speed that up if it becomes useful to do so. But that is That is um, that is an expectation that we should have, that it's going to take a few years. Before you begin that process, you want to make sure that your company owns the, the patent application before you begin, because you don't want to discover after you've gone through the trouble to get a patent that, well, the inventors still own the invention, and that's a problem, but that problem is easily solved with a document called an assignment that says, I do hereby assign my invention to my employer. That's typical to the company that is going to then pursue that technology and build a product around that technology. And that assignment, interestingly, that can happen long before the invention happens. I do hereby assign inventions that I will make in the future for my employer. That's fair, that's enforceable. So then once you own your patent application, it becomes a process of negotiation with the patent examiner to find what is patentable in your disclosure. And it really is a negotiation. But it's not an adverse kind of situation. Fellow panelist Doug Lineberry will agree, I'm sure, that you and the patent examiner are really on the same team. You both want to issue a strong patent. You don't want to issue a patent that you don't deserve. You don't want to have that in your portfolio, because what do you do with it? It becomes more of a problem, I think, than the problems it might solve. So you're going to be working closely with your friendly neighborhood patent attorney, and there are two of us here on this panel today. Another important consideration is that enforceable rights attach only once the patent issues. There are things that you can do with a published patent application that give you some additional benefit once the patent issues, but the bottom line is the patent has to issue before you have any legally enforceable rights. So you can mark your product with the words patent pending. I think that gives you great marketing value. People say, oh, this is new and improved technology, and it's so fresh that the patent hasn't even issued yet. That's fantastic. It also lets your competitors know that, hey, they need to keep their eyes open for patent applications that might publish, patents that might issue that protect your product before they just blindly go and start copying it. But to say patent pending, it confers no additional legal right to you. But like I said, it might have marketing value. In all cases, you want to make sure that the patent or patent application fairly reads on the product before you mark the product with the words patent pending, or in particular with the words, with the patent number itself. If you are careless about this, it could be patent misuse, it could be unfair competition. These are things that we just don't want to stray into. Yes, it's great to brag about your patent portfolio, but you have to use it carefully. Next slide, please. Okay, how are we going to manage these costs of getting a patent? A patent costs $30,000 to $50,000 per country over 20 years. The higher number comes if you have to translate into, say, Chinese or some other language other than English. Many countries do use English as their official language for patents, or they accept English, and that's fine. But even so, we're talking $30,000 on the low end. Well, that investment makes sense only if it is protecting a commensurate value, whatever that might mean for you. It could be $1 million a year in revenue. It could mean a dispute avoided, a lawsuit avoided. But it is an investment, and you should be seeing a return on that investment. Otherwise, I refer you to the keep, sell, kill analysis we talked about a moment ago. Another way to lower costs is to see whether you are a small entity or a micro entity. Small entities, their government fees are cut in half. Micro entities, their fees are cut in a quarter. So, that's a pretty good savings. You have to be very careful, make sure you are in fact a small entity or a micro entity. A small entity has 500 or fewer employees. And this also includes nonprofits such as universities. Or no matter how many employees the university has, they are still a small entity. Microentities typically will see an individual who has 5 or fewer patent applications or patents and makes below a certain amount of money on the order of about $157,000 a year. There's a little formula that they have to figure out whether you're a microentity. But hey, if you do qualify, don't mind disclosing that in the public record, then you get your fees cut down to 25% of what the large entities are charged. If you file your responses timely, you can avoid extension fees. Extension fees start at $100 for the first month, $300 for the next month, $700 for the third month, and it goes up. And then, of course, there are some things you can only extend 3 months. Some things you might be able to extend a little bit longer, a couple months more. But of course, let's just file by the deadline and save those fees. Also, maintenance fees. Let's not forget about maintenance fees, and they get expensive as time goes on. Those need to be paid by their deadlines, or the patent will expire. Next slide, please. Okay, and now I turn it over to our other friendly neighborhood IP attorney, Doug Lineberry.
Thanks, Jeremy. Everyone, what we want to do today is to enforce that you have a valuable asset. That part of what we're here to basically achieve after this 6-session segment is we want you to understand what you got and how to protect it. Foremost, I want everybody to mark their trademarks. I know this sounds silly, but everybody on this call or everybody on this Zoom who has a business has a trademark. It's a given. You may have a service mark, meaning you provide services. You may have a trademark, meaning you provide goods. You can use TM for both. Service mark, again, is only for services. But the one thing I want you to know is avoid the Circle R until you have registered. Just like Jeremy talked about with the Patent Office, we have to negotiate with the Trademark Office. We can't just put a Circle R on it all as well. If we do that before we have an actual registered trademark, we are going to have what's called a fraud situation. I would prefer we avoid that. You would too. But what I want y'all to also realize is protect your valuable marks. And at the beginning of your business, I'm not saying protect everything. I'm saying there has to be a critical business decision, kind of like Jeremy talked about which countries you file in, or what do we do with these patents once we have them. Protect your important trademarks. I'm not saying file for everything. File for the ones that protect and make you money. Jennifer, if you don't mind, would you go to the next slide? Thank you. Now, trademark fallacies, guys, we can learn a lot about what people commonly do wrong, and that way you won't do the same thing. A lot of folks think, hey, I own a domain name, therefore the trademark is mine. Absolutely not the case. You can own all the domain names you wish or all the trademarks you wish. You may not be able to get the other one. But importantly, if you own a domain name and you do not have a registered trademark, you're not using that in a trademark sense. It is simply a website address on the internet. Kind of like the address for your house. That's not a trademark, it's simply a location. So I want everybody to know that just because you own a domain name or URL is not the same thing as owning a trademark. Next, going to the Secretary of State and using them to clear your marks is a bad plan. The Secretary of State of South Carolina will allow 1-letter variances. You won't get that for trademarks. Indeed, you may see someone think, oh, I add S to it, and that's okay. Sure, that might work at the Secretary of State office. It will not work for the Trademark Office. Indeed, you're probably going to be hit with the likelihood of confusion because guess what? You're too much like the other mark. You're just a letter different. So don't fall for that. One thing, like Jeremy said, hey, we want to do a patentability search for a patent. We want to do a clearance search for a trademark. If you see marks that are like yours out there, avoid them. In this social age, guys, consumers don't stop to try to distinguish, is this person from South Carolina? Are they from New York? Are they from Texas? They'll simply see that, hey, X company makes a bad product, or X company gave people food poisoning, or X company's bus line crashed. They're not going to try to figure out where this person's from. So if your marks are too similar to someone else, you may be impacted by their bad acts. That's another reason to come up with original marks and to avoid being too close to someone. Again, changing a letter or two might work at the Secretary of State's office. It will not work in trademark parlance, and indeed, you should avoid that. Also, if the USPTO approves my mark, no one can ever challenge it. There's actually a couple ways third parties can do that. One is an opposition. You'll skate through the PTO. You and the examiner have gotten along. They're getting ready to publish your mark. They publish it. Lo and behold, here comes a third party saying, hey, your mark for XYZ is too similar to my mark for ABC or XYZA or whatever it may be. That potential exists. There's also what's called a cancellation proceeding, meaning that they may file what is called a federal lawsuit against you to have that trademark canceled. They may simply send you a cease and desist letter. So there are a lot of ways that getting a mark through the trademark office are still open to assault via third parties. Now, one thing I want to iterate, just like Jeremy did, pay attention to your trademark filing deadlines. At the 5th year, your trademark can be rendered incontestable. That means that it is much more difficult for a third party to try to take adverse action against your mark. If you are rendered incontestable, meaning that you file the appropriate documents by the appropriate time, that is a huge plus for any trademark. It renders you incontestable to these third-party attacks. It raises the burden for somebody to try to even challenge a trademark. But if you miss that deadline, you miss that opportunity, and your mark may go abandoned. So just like with Jeremy saying, hey, pay attention to these deadlines, we mean it. Pay rapt attention to all of these deadlines. If you do not, you will pay the price. Now, I did see one thing, good question from Christine DeVlaming. She said, what happens if an inventor's left the company and you have a patent app out there? This is the same thing that I would like to mention. Jennifer, if you would, next slide. When we do this, guys, trademark, patent, copyright, and trade secret, they are not distinct slices of pie. Again, I try to describe it like a casserole. Some pieces may have more patents, some pieces may have more trade secret, but what you're talking about in this case, Christine, is an assignment. If you are dealing with anybody who is not your employee, you absolutely, positively, no hesitation, must get an assignment from them. And I'm talking for copywritten works, I'm talking for patented works, I'm talking for your trademark logo, guys. If something is created by someone who is not your employee, you absolutely, positively get an assignment. You may have heard of the concept of work made for hire. It's esoteric. It deals with 9 very specialized things that unless you're a cartographer or some sort of testing expert, that's a problem. What we want you to do is to always get a signed writing from any independent contractor, again, someone not your employee, who works for you. And I don't care if it's your sister, I don't care if it's your best friend, get this assignment, guys, because one thing Jeremy and I see a lot is that people will come to us and say, I own this. That's not the case without an assignment, guys. You think you own it, you hope you own it, but you may not own it. Also, with respect to back to the trademark copyright realm, hey, I paid for my trademark logo so I can use it as a wish. Not if you don't have an assignment. If you did not get the copyright artist who designed your trademark logo to assign those rights to you, you simply were given one iteration of it. That one piece of either a digital JPEG, maybe a piece of paper if this is person's old school. But if you don't own the copyright, you don't own your trademark. You can't take it out and run with it. These assignments, guys, are critical. I cannot underline enough, cannot overemphasize, they are critical. Also, a lot of people think, hey, once I get my mark through the trademark office, I can change it. I can do things to it. You can make very minor changes, and these are select changes, maybe like deleting a space, inserting a space, dropping an S, dropping a V. You cannot make significant wording changes. You cannot, for a word mark, start using it with distinctive stylization. When this 5 years comes up, and then every 10 years after that, to renew the marks, if you have made significant changes to the mark, you may lose the mark because this mark still needs to be true to its original iteration. One thing I tell my clients is, hey, if you're going to file for a logo, file for the words too. Because if you'll notice, words stick with brands. Look at Coca-Cola, look at NASCAR, look at the way these brands have evolved over the decades that they've existed. But the key tenet to both is Coca-Cola and NASCAR. Those words are always there. Protect your words separately from your logos. I suggest you do that first after a trademark search. A lot of people also think, and Jeremy gets this as well, I put it on a hat, I put it on a trademark, I'm using my trademark. You're absolutely not. You're decorating something. A trademark is your brand implement used in commerce with goods or services. Slapping that bad boy on a t-shirt is simply decoration. Cynthia, I see you popped up saying, can you get an e-signature or using online design services? Sure, as long as it's a valid signature. You know, we've gotten to where we do allow e-signatures to count. I mean, heck, I filed trademarks this morning that I e-signed for the clients with permission. So yes, they do count, but I need you specifically, Cynthia, to hold on to a print copy and a digital copy. And those two don't live together. I want you to have a backup copy, neither the digital's the backup or the print, and I want those in separate locales. This is just a good backup plan in case something happens. You know, we've seen the power outages that everybody's experiencing due to the storm. You know, some of us are prone to flooding. We do not want all of our backups in the same spot, and we do want multiple backups so that we can show that, hey, this was e-signed. I own my design. I'm safe. But if you don't have that, Cynthia, that's a problem, because I promise you the vendor will only keep this for a certain time before they delete those files, de-riz them, or whatever they do. Also, I can use a circle R on my mark anytime I want. I'm coming back to this one, guys. One thing that Jeremy and I see a lot is you will get a specimen back from somebody to show use that'll have the circle R symbol on it. And that causes us to blanch a lot, because what you've done is you've misrepresented to the public that, hey, I've already gone through this process, when indeed you're still in the process. So do not use circle R until you have a registration. Jennifer, would you hit the next slide, please?
Hey, Doug, there was one other question. Do you have a
Yes, ma'am.
second? Someone wants to know, is there a special form for assignment, and does it get notarized?
Yeah, great question. Christine, great question. Yes, there has to be specific language to an assignment. Do not, and I'm emphasizing again, do not pull one from the internet. That is a terrible idea. It may not withhold. It may not even be internally consistent, but absolutely. You can notarize it if you want to. Typically, 2 signatures is good enough. The person assigning, the person it's being assigned to. I will also tell everyone here, you want your IP to be owned by a corporate entity. I'll do that slow because I know I talk fast. You want all of your intellectual property to be owned by a corporate entity. I don't want it to be a personal Jennifer Groff piece of property. I don't want it to be a Cynthia Rhodes piece of property. I don't want it to be a Christine DeBlaming piece of property. It doesn't need to be a Doug Lineberry piece of property. It needs to belong to a corporate entity to have the benefits and protections of the corporate shield. But again, that is a great question, Christine. Yes, there is specific magic words, has to be used. It can be done wrong, and then it's completely void. You absolutely, positively want an assignment from any independent contractor that is producing things for you. And guys, I'm talking websites, I'm talking software code, I'm talking logo designs, I'm talking inventions. I am talking the entire gamut of IP. If you have someone who's not an employee working for you, get an assignment. I'll tell you to belt and suspenders and get an assignment from the employee as well, just in case, because it'd be better to have it than to later on want it. Or, Lord forbid, we've classified somebody inappropriately as an employee, they're actually an independent contractor, and we lose that benefit. Now, moving back on the copyrights, and guys, feel free to ask questions. We will stop the second you raise them. We love questions. They help everybody understand, and there's never been a bad question ever asked, period. For our copyrights, guys, copyright notice is a little more complex than trademark, but you can use the full word copyright. You can abbreviate it COPR. Typically, you want to put in the year of publication or the year of creation if it's not published. Publication for a copyright is essentially making it available to others, offering it for sale, offer it for licensing, putting it out there in the chain of commerce. Name of the copyright owner. Now remember, I told everybody I don't want to see Jane Doe's. You'll notice I did a Circle 2021 Doug Lineberry down there. That's a trick. It should be Circle 2021 Burns Foreman LLP, my law firm, or Thrive IP, Jeremy's law firm, or if Jennifer has an LLC called ABC LLC, it should be that. Because what we don't want to do is to have IP residing as personal property, guys. That means in a divorce, it's in the game. It means in a lawsuit personally against you, it's in the game. We do not want that. Once you try to sell your IP, once you try to license, or once you try to go up for venture capital, you'll be called to task on this and asked, hey, how is your IP protected? You're kind of like Jeremy and I have been talking about all the different forms, but they're also going to say who owns it. And you better make certain that you have those assignments, and you better have it assigned to a corporate entity if you want this to be as smooth as it can be. Jennifer, would you mind hitting the next slide? Now, guys, our copyright fallacies, just like our trademark fallacies, without an assignment, the copyright resides with the author. And again, this isn't the full-blown copyright presentation, but if somebody creates a website for you, if somebody creates software for you, if somebody helps you come up with program materials, if someone comes up with an innovation for you, or any sort of design, it could be jewelry, it could be a machine, it could be a boat hull design. There are a lot of things that copyright covers. If you want to have the right to copy, the right to make copies, to distribute copies, you have to have that artist supply an assignment. Verbatim, full stop. If you don't have that, you don't own that particular work. And again, that could be logos, text, code, statues. It covers a plethora of things. Music, videos, guys. Copyright is so broad, it's almost frightening. Don't be afraid of it, but make certain that we do have our assignments in place. Again, back to Christine's question, any wording will do? It absolutely won't. There have been cases to where people have used forward prognostication language of I will assign, I intend to assign, I'm gonna assign, I pinky double swear I'll assign. That's not good enough. It has to be a present sense assignment. Right now, today, February 16, 2021, I, Doug, give to Jennifer. Right now, I, Jeremy, give to Jennifer. That sort of language to get it across. Now, again, one thing we told you guys too is our intellectual property spectrum, it's more like a spaghetti casserole, folks. There's a little bit here, a little bit here. Some sections may be more than others, but they are not existing independently of each other. And if you think, hey, because I've got a trademark, I own the copyright in my logo, that's not true. I see all the time, folks will go up to a design agency, they will come in and say, I want to trademark this. I'm like, I'm glad to help. But the first question I ask, just to mess with them, is who owns it? And a lot of people are like, silly boy, I own it. The problem is, without an assignment from that artist, you don't own it. All you own is that single iteration. And we cannot protect that as the trademark office. We cannot use that for a copyright. We can't use it for a trademark protection because we don't own it yet. Oh, I love it. Christine's like, hey, a couple things. Leek, I got a question from you. So let me step back. Christine asked one first, then I'll hit Leek and Christine again. My brochure design team has to assign the copyright to our company. If they're your employees, Christine, they don't. Again, I'm a big fan of doubling up on that. Getting an assignment from your employees and sort of just a full disclosure, hey, I've been asked to create certain products for the company. Here they are. You can do that without having to do it for every iteration of it. But if your design team has independent contractors on it, absolutely, you get an assignment, full stop, no pass go. Leek says, hey, how much should we expect to pay for a logo trademark? Great question. Typically, pricing should be around $800 to $1,000. Some of that depends on complexity. That's excluding the fees for your trademarks. Typically, there's a $250 fee if you use the government language, a $350 fee if you've got something unique and want to use your own. So you're looking at roughly between, let's call it $1,100 to $1,400 to have it properly searched, prepared, and filed at the PTO with those fees paid. I realize that's a lot of money. Talk to your attorneys about setting up a payment plan. One thing you'll understand is that I appreciate small businesses. Jeremy appreciates small businesses, guys. We understand that sometimes money is a booger. Please don't let the attorney be a holdup. One thing I want you to learn is how to negotiate and how to haggle. Haggle with your attorneys. Say, is there a better price? Is there a payment plan? What can we do to help me as a small business move along? And again, I want to give a commercial to the SBDC real quick. Guys, absolutely use them. Guys like Tony and Earl, Tony, whomever you may be, Bernita, whichever part of the state you happen to be in, y'all, it is awesome to have this resource. Absolutely use it. It's free. In case I didn't mention that, I encourage everybody to use them. Stepping back down to Christine, she says, hey, the photographer owns all of our photos. Yes, they do, Christine. And I hope they are contracted. You want to make certain that that contract assigns it to them. It could just be a contract that says, hey, I'm going to pay you for photos. That's awesome. But if it doesn't assign the copyright and all those photos to you, it fails its essential purpose. You want to make absolutely, you say we do not have an assignment. If this person's not an employee, you need an assignment. And again, guys, I cannot overemphasize this. If you do not have those assignments, you do not own that copyright. You do not own those photos. It still resides with the photographer unless they're your employee paid to go take pictures for you and they qualify as an employee. Last thing for this one, it doesn't matter who owns the copyright. I'm telling you again, you want it owned by a corporate entity. Get you that personal protection. If you get divorced and your trademark's in there, guess what? The spouse may take it as part of the settlement. And then you've crippled yourself because you no longer own your branding piece. You try to sell it later on, and lo and behold, there's a court order saying, hey, wife or husband now owns this. That's a big problem, gang. Next slide, Jennifer. I think that might have been it for me. One last one. People do come up with a huge misconception that they can take and change a copyright by some percentage. It's a fallacy. It doesn't exist. If you can look at the two pieces and say, hey, it looks like this one came from the other one, and worse yet, they can show that you had exposure to the original and then you went out and made another copy of it, guys, probably going to be found to be infringement. So I need you to be very careful of derivative works. You can't just use a Star Wars movie poster, change the color of the lightsaber, and voila. You can't change Darth Vader's uniform to purple and say, woohoo, new stuff. Disney will be on you like a hot ton of lead. You need to create your own independent IP. If you start mimicking others, you're going to want a license. If you want to be able to turn Darth Vader purple, go to Disney. Probably won't let you do it, but they might talk to you about it. Also, poor man's copyright. That and a poor man's patent, guys. We're now sophisticated patent individuals and trademark and copyright and trade secret folks. There's not a poor man's anything, guys. You will get the value you put into your IP. If you go to LegalZoom, if you go to any of these fly-by-night trademark or patent companies, guys, it's going to haunt you. There are more horror stories about that than there are in any Stephen King novel. I do not want anyone here going to those groups. You go to a Jeremy, you go to a Doug, you go to a Sheila, you go to a Rebecca, you go to somebody who is an IP attorney in South Carolina. Because guess what? You get ticked off at us, there's this little thing called the South Carolina Bar. And it will bring me and Jeremy to Hill quicker than you can say bad idea. But if you go with these fly-by-night companies that are somewhere else, you have very, very, very little chance of getting anything from them. They will not keep you apprised of your trademarks. I mean, heck, part of the reason to hire Jeremy or me or another attorney is because we have a docket system, and it tells you when that 5 years is up. It tells you when that decade's due. It tells you when the maintenance fees for your patent are due. And it tells you way in advance, so you can start budgeting for these. But if you don't have that protection from an attorney, you absolutely will not get it from LegalZoom and these other places because of the malpractice risk that they intentionally seek to avoid. They put the burden back on you. Everybody here is in business. They're not here to be some sort of calendar scribe. Guys, we got a couple. Yeah, I love this. I'm getting ready to kick somebody. Hold on. Okay, Christine, you are my straw lady. You're going down to a poor man's copyright that is a design I mailed to myself. You have nothing, my dear. You really don't. You did design it yourself, so you're the author. That is awesome. But I tell you this, putting it in the envelope, putting a stamp on it and getting it back utterly is useless. It proves nothing. But since you are the original artist and you can go back to those drawings and say, hey, I was working on this in September 2019, that's what you keep. Do not worry about stamping a letter on this. And I don't care if it's sealed. It can be sealed with the Queen of England's wax stamp on it. Doesn't mean anything. It is not a poor man's anything. It's not a patent. It's not a copyright. You want a copy of the slides? Oh, my dear, there's a catch for that. But we'll give them to you. Tony's about to tell you how.
Well, I think Carolyn will. Well, actually, as we will after this presentation, Carolyn from our office will be sending out a survey, I believe, and if you bring that survey back to our offices, my understanding is that you will be granted the right to the slides.
That is correct, Tony. All of those individuals that confirm their attendance, I will email the survey out this afternoon. And if you respond to that survey via email, then I will distribute the presentation slides on next Monday. And that will give everybody the opportunity to respond.
Thanks, Carolyn.
All right, so I guess I'm the last guy today. Thanks, Doug, for that shout out for SBDC. We certainly appreciate that, and we do our best to help out in these situations. So the one thing I hopefully you've gotten thus far is IP represents value in your business. I think every single speaker that we've had so far today has touched on the fact that this has a far-reaching impact on your business. The idea creation, development, testing, all of that is proprietary data that you are putting together to support the fact that you own this, that it's unique. You have time and costs involved with this, so there's value in that. You have competitive advantage by owning this, so there's value in that as well as the branding and reputation that might come along with the fact that you have this in your possession. And of course, the actual monetary value and at the point that maybe you want to sell it comes into play. So I'm here today to talk to you a little bit about protecting it from some outside threats that maybe you hadn't thought of. So if we get the next slide there, please. So what exactly are we protecting this from? Well, obviously the theft or use of this property by others is what we've been focused on to this point, but specifically, I want to drill down to the theft by form of a hack, a cyber attack, a cybersecurity breach, something along those lines. So these might be things that you've heard of in news headlines, hopefully not associated with your company at this point, but maybe you've heard of phishing or ransomware, possible email spoofing, or any kind of bad actors or malware out there that come into your systems and either hold you hostage, steal your data, encrypt your data so you cannot gain access to it, pull that data and use it somewhere else, release it to a competitor. All of these things are things that can occur simply because you've not been able to protect your intellectual property from attacks from cyber criminals. These attacks are getting more and more sophisticated. They're getting more and more numerous. And with the advent of COVID and everybody going with remote workplaces, this has become a major issue for small businesses. So just know that you are a target, even though you're a small business, and the ability to protect yourself from these types of risks are becoming more and more difficult. The other thing I want to point out, that last bullet there, that it says you are the biggest risk. When I say you, I mean you, the person, the individual person, the employee behind the counter. Any human factor really is the weakest link when it comes to protecting yourself from cybersecurity. So having well-trained, well-educated, well-informed employees and owners is one of the best ways for us to protect small businesses and help them protect their IP and therefore the value in their business. Next slide. So the last thing I'll touch on is just how might you mitigate some of this risk? Well, certainly, as I just said, you must be continuously improving your security. You must have well-trained employees. You need to stay up on what the latest threats are. And how do we do that? Well, you can certainly perform some basic cyber hygiene self-assessments. The SBDC has those available, as well as many outside resources that can do that for you. You can do internal employee training, or you can work with an SBDC or a third-party cybersecurity experts to produce some training for your employees. You can do testing as well. So there are actually some services out there, free services, that can allow you to send test phishing messages, say, as an example, to your employees to see how many people actually bite on something like that. So just know that you can get out there and use some of these tools to help educate yourself, your employees, and test your internal systems. So the SBDC has a cybersecurity team that we can put in place if you have need of that. We do use standards-based SBDC self-assessments. These are based on NIST and the CMMC model. For those of you who are in the Department of Defense and contracting world, you know what those two organizations are and what they represent. All of our testing programs and all of our training are based on that. Our third-party resources are also available. So if you're having difficulty trying to connect the dots, figure out who I should call and what questions should I ask and what's a good expectation from some of these resources, just dial up your SBDC and they'll get you in contact with our cybersecurity team, and we can help you through that selection as well. So get out there and protect yourself from the cyber criminals and protect the IP and the value in your business. I'm going to hand it back to Jennifer, and I think we'll close out with thank yous and questions.
Thanks, everyone. I think most of the questions have been addressed, except there was one for Jeremy a little earlier, which was, why does the patent process take so long?
Yes, thank you, Christine, for that question. And thank you to all the panelists for all of your words of wisdom. Why does the patent application take so long? It's because it is an examination process. The examiner has to go and look up all the television patents that may have come before your remote control television patent application. In contrast, there are also registration systems. Like, for example, your fishing license. You just show up, you pay your fee, and you get your fishing license. You are not, nobody asks you, well, how many fish can you keep? How big do they have to be? You're not quizzed on the requirements for the fishing license, so it is just a registration process. Whereas, for example, your driver's license is an examination process. Can you really drive a car before we give you a driver's license? It's that way with patents. They actually examine whether you deserve the patent before they give it to you, and that's why that takes so long. Christine also asked the question, what if the inventor left the company and you have a patent application out there? There are things that you can do to proceed in the situation where you've got an inventor who is not assigning the application to the company. If you can show that they have an obligation to assign, or if you have to reach into employment law, show that they are an employee, number one, and number two, that they were hired to invent. It can be said that indeed the company does own the patent application, but as Doug so eloquently and emphatically stated, you really want to try and get that assignment, and it's better to try and get that assignment even before the invention happens, with the words, "I do hereby assign." Even future inventions. So short answer is there are things that you can do. So they may be successful, but this is why you attend this kind of webinar, so that you can establish good practices going forward.
Yeah, and I don't see any other questions in the chat, but if y'all want to post some, that would be great. Or I guess I can ask a question of Jeremy, since you were just talking. We talked about how prior disclosures of inventions can harm your ability to obtain patent protection. So, are there disclosures that would be okay, like a department seminar presentation, or if I describe my invention in like a grant submission?
The answer is no. That's the short answer. The longer answer, I actually went and looked these things up in preparation for today's webinar. If you disclose in a federal grant application your technology, well, there is a statutory requirement that information about awarded federal grants have to go on to this website called usaspending.gov. And if your invention is disclosed there, hey, I got a grant application to work on the warp engine, then you might not be able to get a patent on that warp engine, but that also turns on how much disclosure is actually publicly available. If you describe how to make and use a warp engine and you're working how to make it more efficient, then that could be a problem. But if you're just saying, I hope to learn more about potential warp engine that I haven't even invented yet, warp engine, there, I said warp engine. I haven't invented anything, I haven't disclosed anything. So it depends a little bit on your disclosure. As far as sort of research meetings, again, I say no, and here's why. You can protect a seminar discussion. Hey, everybody, we're all scientists at the university, let's say, and these are my research results. I've come up with this composition that contains ABC. Okay, that's my composition. It's going to cure cancer, whatever it might be. That's great, but to protect that disclosure and prevent it from becoming, let's say, prior art or starting that 1-year clock, there needs to be what's called a joint research agreement in place. Number one, everybody who was part of that disclosure, who received that disclosure, is party to that joint research agreement. The disclosure has to fall within that joint research agreement, and the patent application has to include all the people who are parties to the joint research agreement to prevent that disclosure from being prior art or starting that 1-year clock. Bottom line, there's a lot of hoops to jump through to use the joint research agreement loophole to prevent your disclosure to all these other scientists as prior art against you. So I refer to my previous answer, no. But let me refine that a little bit. You want to be very thoughtful about when and how you're going to disclose your invention. Christine follows up with a question. We should always have a non-disclosure prior to talking to potential vendors too, right? That can help potential vendors, potential customers. That can help under US law, whether a disclosure is public disclosure or not. In some circumstances, they do look to see whether there is a confidential relationship. That includes that confidential relationship can be established by a non-disclosure agreement. However, if it is a bona fide offer for sale and the invention is ready for patenting, a non-disclosure agreement isn't going to help you in that circumstance. So answer, non-disclosure agreements help and are useful. I encourage them, but they do not necessarily prevent a bona fide offer for sale for an invention that's ready for patenting from being prior art against you. So from day one, before day one, think strategically about how you will disclose your technology and how you will protect it. So we're asking the questions ahead of time rather than after the horse gets out of the barn. Thank you, Christine, for these excellent questions.
Yeah, thank you very much. I just want to make sure we have one last slide before we go. There may be other questions as well, but I don't want to forget to remind you all that there is a session next week. Next Tuesday, Elizabeth Daughtry of the U.S. Patent and Trademark Office will be giving a special presentation. So make sure you come back for the last session in our series.
Jennifer, we might have time for a couple more questions if everyone is okay with that.
Well, let's see. I guess. What about a question for Doug? I know there's one that I'm interested in. It's if something on the internet describes the author as unknown or anonymous, am I okay to use the work?
Jennifer, that is an awesome question. The answer is not no, but hell no. I had a client. I'm serious, guys. I cannot. This is another can't be overemphasized issue. Folks view the internet as kind of like this great big yard sale of stuff. It is a minefield. It is a minefield that sometimes cleverly disguises itself. I literally had a client caught in this situation. They made textile goods. They had somebody who they thought was being thorough on this, went on the internet, found the poem. It's only 12 lines long. I mean, it wasn't the Magna Carta or an encyclopedia. They put it on towels, and it was very cool, and they sold 70,000 some articles. Well, lo and behold, the author of the poem bought one of the towels, sent it back to us very kindly with a copy of their copyright registration for that 12-line poem. And the person who had researched it for the client freaked out because they had kept a copy of the website page that said anonymous. But guys, herein lies the rub. Simply because a page on the internet says something, it doesn't mean it's true. And in this case, we had a copyright artist who came to us and said, look, you've used my poem. And guys, at this point, it's just a matter of making it rain for the author. There's nothing you can do. We infringed that copyright. We made 70,000 infringements actually, and we had to go back and pay them for it. So no, the internet, guys, is not a grab bag of take it and run with it. And I'm talking music, I'm talking video, I'm talking pictures, I'm talking text, I'm talking general appearance of a website. None of this is up for grabs, guys. If you want to touch somebody else's stuff, you better have a license to do it. It looks like Christine's got a new question here. Can you use some print material if you notate the original book and author name? Oh, Christine, I love it. What that does in this situation is it makes infringement easier to prove. You're thinking about the fair use doctrine. Fair use is this. It's a 4-factor test that says, hey, you know, you may be able to get away with something, but if you take from somebody and it's a work of fiction rather than a work of fact, that leads it to be considered for profit. If you're using it for a profit motive, like, hey, read this book excerpt, then buy my product that somehow associates to it or whatnot, that is a direct profit motive. Also, if you impact the market for this particular good, because if they'll now come to your website or view your video instead of going to the original owner, and that costs the original owner profit, that's a problem as well. It also depends on what you take, Christine. Like Napoleon said, quantity has a quality all its own, but if we take the last couple pages of Prisoner of Azkaban and we find out that Sirius Black dies, there are a lot of people who wouldn't read the book after you told them that. And if you post that on your website, it might just be a couple pages of a several hundred-page book, but it's a critical portion of it. And what I want us all to realize, guys, is the internet is not a cut and paste grab bag. Do not do it. Do not take your legal documents off of it ever. Come to a Jeremy, come to a me, come to somebody. Do not do your own legal work off the internet. It is a disaster waiting to happen. Do not lift things from people's websites. Do not sample music. And also pay attention. I got another question. Looks like this is from Leek. There's a lot of cloning of pages on Facebook of owner selfie photos. Is it possible to copyright your own photo image if you take it? Luckily, I have a commercial photographer that had the copyright images, and it was the only way to get Facebook to delete the cloned account. Okay, guys, a lot of problems in that one question, Leek. Whenever you use Facebook, you essentially give them equal and opposite ownership to your IP. Go back and read that Facebook platform IP. It will put you to sleep. So third or fourth reading, you'll make it through it. But you need to go back and read what you're agreeing to. And you're trying to say, hey, you know, what about these cloned websites? I'll tell you this. If you want to use a photo of Mount Everest, get out your camera. It's cheaper for you to get a picture of it and do it yourself than it is try to lift it from somebody and hope. Because, you know, what if, we're talking about derivative works now, what if it's the angle slightly different, but everything else you mimic from that author? There are a lot of problems there. And I'm a big fan of you either get a license or you do it yourself. And if you have something you think is just untenable and I have to do it the way the author did, track them down. But like Christine said, just quoting something to them, doing the attribution of it, that literally is just saying, I took it from this person. It makes it so much easier for attorneys like me and Jeremy to be like, hey, you actually admitted you took it. Look at page 4 of your website. Okay, Christine says, better to refer that someone get the book directly for the info. Absolutely. You know, if you're wanting to talk about something like that, and especially if it's a motivated website that's there to help your business sell and make money, you don't want to start lifting stuff from other people's copyright works. You're going to lose that publication ability almost instantly. You'll use the ability to say, hey, you know, this is fair use. That's really for only commentary and educational works, kind of like today. You know, if we had photos of Nicki Minaj and her latest defamation suit in here, we're educating you on it. You know, we're not trying to make money off Nicki Minaj. We're not trying to take away from her rap career. But what I want y'all to understand is that we have to be very careful in selectively taking these items. Don't selectively take any of them. You have a license to do it or you make it yourself. Rochelle has a question. As a motivational speaker, how does that apply when persons take your quotes and post it on social media as though it's their own words? You know, Rochelle, you're asking a great question. We in the IP world have to wag our own tails. If you see someone using your copywritten materials, you want to be able to show it's yours. So have a website, have data materials, maybe keep a log of when you come up with these things. You know, keep those records, like I was telling Christine earlier, to show that you're the author. And then you reach out to them nicely, very nicely, because remember, this is the digital age. It's very, very easy to quick record on a Zoom or record on a call or just to hold up one of these blasted cell phones and copy whatever you want to or record whatever you want to. What I want you guys to do is in a very nice way, reach out to this person and say, hey, that's mine. Now understand, copyright does not protect particularly short works, but if it's a motivational paragraph or something, I think you're on firmer ground. Or if it's something that's become famous, you're definitely on firmer ground, like got milk. Even though that's a 2-word phrase, there's been case law that's found it is famous enough to deserve copyright protection. So if you've got something along those lines, you reach out to them nicely, church language, nicely, because again, Jeremy or I do not want to get a tape of you ranting and raving at somebody over a phone. We'd rather you come to us if they tell you to pound sand, and then we will tell them to pound sand in legalese and the problems with their pounding sand and touching your sand. But I do not want anyone here being a hothead. I want you to handle this professionally. I want it to be addressed in a nice, direct manner. And if they don't work with you, you find your attorney and you get them to handle it. You do not get nasty. Nasty does not pay, folks. Does not pay. Guys, great questions. Do you have any more? Sure.
Yes.
Leak says, can you address Facebook images further? Should we not post or sell product via the platform? That brings into question a Facebook business page. And Leak, it cut off at I. Yes, I do want you to consciously decide what you put on Facebook. I first want you to go back and read the snooze language and understand what you've already been giving them. You're giving them equal and right copyright to your posting it. And it's called consideration. They let you use an electronic platform. They in turn get to use the media that you put on the platform. That's the exchange you made to use Facebook. If it's something that you want to control, don't use Facebook. Use a platform that doesn't do that to you. Cynthia Rhodes, if you run a blog, should each post be copyrighted through an attorney? Cynthia, I actually teach people to do their own copyrights. I suspect Jeremy believes the same thing. It really is a straightforward form. Once you fill it out a time or two, it ain't rocket science. If you can pay $65 and upload a JPEG, you're as complicated as the Copyright Office can make it. And I'll tell folks this, if you create a lot of copywritten material that looks like you guys do with that blog, I'm not saying copyright everything. It's kind of like trademarks. Don't trademark the dumb ones. Trademark the ones that make you money. But if you've got a blog and you want to do as a serial, you can file all the articles for a particular time period in one piece of work for a $65 fee. I'll caution you though, that if you have a blog that you think is just penultimate, that you've knocked it out, that this is the Magna Carta, I've done such a great job on this, do that one by itself. Because if it's that good and you think other people have a chance to take it, I would rather we have a smaller registered work to show that, hey, the quantity they took was small to begin with, and here they are taking a critical portion of it, than saying, oh, look, we filed a serial that had to have 62 blog entries on it, and they took one portion of one small blog entry. You get how that argument weighs to a jury or a judge, but if you have a great one, if you're like, piece de resistance, you file a registration on that one. Then if somebody tries to take it, you can take that single registration, go back to them and say, hey, gang, 72,000 items with my poem printed on it. You owe me some cash. Great question, Cynthia. Leek, that's a great question. I'm not a social media person. I don't do Twitter. I don't have Facebook. I do none of this. What I would tell you to do is to read it. They do have to tell you what the obligations are. Do I have one I would recommend? I don't, but I'm not saying there's not one. I'm just saying you're going to have to hunt for it and find it. Now, this may be an Earl Gregorich question to see if he knows of one that doesn't have some sort of similar thing to it. But I'm telling you right now, read that language, especially the IP, because you may be giving away a lot more than you ever thought you did.
And my short answer to that would be, I am not aware of any social media platform that does not claim ownership to the content you add to it.
Yep.
Tony, are we about out of time now, or?
Probably so, unless there's any more questions. I think someone, Leak added
Just
to.
came back into the game on us, Tony. He says, what if I delete the content? Leak, that's a problem. You've already published it with them. You've already given it to them. If you try, you can't put the genie back in the bottle. Once you put it on that website, they got it. And trust me, their servers have it. And you're thinking, oh, well, I can take it back and they probably won't have it. Nah, no way. The second you post that, man, it's on there. So think before you put it on there, because you can't cram that genie back.
That's a very wise answer for sure, Doug. I think that'll probably do it unless there's one other question. But in any case, I just wanted to, first of all, thank you, Jennifer, for being the moderator today. And again, wanted to remind everyone about next week's session 6. This is where we're very excited to have a USPTO representative in the form of Elizabeth Doherty, who will come and give a webinar regarding the USPTO in general, some of the resources that they offer, and in particular, the USPTO's COVID-19 Response Resource Center. And that has to do with, as I understand it anyway, some relaxing of some of the deadlines that are required in terms of filing patents, which I think is, we talked about today, some of the deadlines and fees that might be involved if you miss a deadline. Well, she's going to talk about some of the relaxing of those fees, is my understanding anyway, in terms of meeting deadlines for the USPTO and patent applications. So please tune in for that next Tuesday, February 23rd. And I do thank everyone for joining us today. Thank you to the panel. You did a great job, everyone. And I guess that'll be it.
Well, and one last thing. Again, I will be sending out the post-event survey probably in the next 20 to 30 minutes to those that confirm their attendance today. And once you respond to that, I will collect that list of respondents and be sending out the slide presentation hopefully by Monday, which is February the 22nd.
Fantastic.
Thank you all for joining us, and we hope you will join us next Tuesday.
Excellent.
Thanks again, all.
Thank you.
Take care, all. Bye now.